fortunate tonight to have Mike Paulsen, law professor at University of St. Thomas Law School in St. Paul, Minnesota, here with us tonight to speak about his new book that he did with his son Luke on the Constitution. An introduction. As I said, Mike is a law professor, graduate of Yale Law School, and an author for us at First Things. He did our Supreme Court roundup for 2014, laying out in probably the clearest form that I have read, the logic of the Hobby Lobby decision in the last session of the court, and even this year, and even probably more provocative decisions will be handed down by the court. It'll be interesting to see how that all turns out. But the Constitution, I'm grateful he's here to speak to us about our a Constitution is a kind of, I suppose, a country's soul, and our basic law reflects our national character in all sorts of important ways. And it's great to have him here to speak to us about the Constitution and its meaning and purpose. Thank you so much, Mike.
Well, thank you all. It's really great to be here. I'm greatly honored to be a guest of First Things, and I want to thank especially Rusty for inviting me, and Denise. Where's Denise? Who set all this up? Thank you so very much. I've had a long and interesting and intermittent relationship with First Things. I was a charter subscriber. I was in the first group of. Now it lapsed for a while in there. I have to concede, but I'm back on, and at least now I'm an author. Rusty called me last year about this time to ask if I'd be interested in writing a review of the Supreme Court's term, and it was great, good fun. We had some editing and battling wars. We had different perspectives, but gosh, it is a pleasure to meet Rusty, my fellow combatant in the wars of public discourse. And then in this May issue, my son and I wrote an article on Lincoln called The Great Interpreter, and that's in this nice green shaded one that's still out and available, and probably some of you have had a chance to do it. And we were doing it, and we were working on pitching our book, right? So when we're told by publicists that when you have a book, you have to do everything you can to publicize it, and you write articles based on. So this article for First Things is in some way an adaptation of Chapter 7 of the book, which is called, very simply enough, The Constitution, an Introduction. And really, I will not be the slightest bit offended if in the middle of my talk you decide you want to walk up and buy it. I've promised not to go more than a half an hour, so yell at me, Lauren, when you just sort of flag me down. But I do want to tell a little bit about the story of how the book came to be. I wrote this with my son, Luke Paulsen, who's now 23, over the course of 9 summer vacations. Okay, and it started this way. I was making an academic presentation a number of years back. I think it's winter of 06 or 07 at Princeton University as a guest there, talking about Lincoln, presidential power, and the Emancipation Proclamation, and drawing some connections between the presidential war powers issues of Lincoln and presidential war powers issues of today. And at the academic dinner afterwards, there were some law professors, and there were some college professors and other guests. And of course, the law professors started arguing with the college professors, saying, when and why did you screw up students so much that they come to law school with all these misshapen ideas about the Constitution? Right? And the college professor said, no, not our fault. It's not our fault. They came to us this way. Right? Don't blame us. Blame the culture. Blame the high schools. blame the media, blame the shallowness of the internet. And I said, well, somebody ought to write a book that's actually geared toward real people, and that actually tries to explain things in a straightforward, sensible fashion, that isn't reductionist, and that actually gives some sound teaching. And they said, well, why don't you do that rather than write all these boring law review articles? and so actually, I was bumped from my flight in Philadelphia the next day and found myself with 3 hours of useless time on my hands. And I sketched out a little outline, and I brought it home and talked to my son Luke about it, who at the time he was 13. And he had somehow gotten into the habit, he'd warm me up for teaching as I was driving him to school. I'd say, what are you teaching today, Daddy? And I'd say, well, I teach civil procedure, so it was like offensive non-mutual issue preclusion. And we'd have discussions about that. So he was always more interested when it was something about constitutional law. Really, there are worse forms of child abuse. But he actually took an interest over the years. And so by the time he'd had 8th grade civics or government and was coming across lines in textbooks that said, the Supreme Court invented the doctrine of judicial review, which means that whatever the Supreme Court says is the correct interpretation of the Constitution. And he would roar with laughing, Daddy, look at this. Look at the nonsense they're saying. And we would have these discussions. So when I came home from my bumped flight and was talking to him about this idea and this discussion at Princeton, somehow it emerged, we suggested the idea of a summer job where he was sort of my informal research assistant. And, at the time I was kind of pitching it maybe toward high school or junior high. And by the end of the night, we had this idea of writing a book together in one summer. You can't write a book. We were like incredibly naive, but we did take a start at it. And at the end of the summer, I had classes to teach, he had classes to take. We put it away and we came back to it the next summer. This started when he's 13. And 3 fired agents, a bunch of rejections, and 9 years later, we finally landed with Basic Books, just uptown, a really credible, excellent book publisher, and we're just very gratified to be doing it. So I wanted to tout my book. I wanted to see what I could do to energize people about it. Let me just tell you a little bit about its structure. The idea is still to explain the Constitution in straightforward, honest, sound terms as best we can. Nothing up our sleeve. We'll call some issues as we see them, to real people. Lawyers and recovering lawyers, I think, will like it and enjoy it and appreciate it at a level, because it's really sort of difficult to try to capture accuracy at the same time that you're trying to make it something accessible to readers. But it's really aimed at general readers. Our elevator pitch is that if this is the one book you would read about the Constitution to give you an overall sense of the whole. We start with the Constitutional Convention, explain the meaning of the core provisions, talk about slavery, talk about the addition of a Bill of Rights right after the adoption of the Constitution. And then the second half of the book is devoted to the history of the Constitution's interpretation over the 225 years that it's been in existence. And so it's divided into epochs. Chapter 6 is about early controversies under the Constitution. Chapter 7 is Lincoln, the Civil War, and Reconstruction. Chapter 8 covers about 50 years. Chapter 9 is the middle of the 20th century. Chapter 10 is a doozy because we tried to deal with all of the modern controversies from 1960 on. But Chapter 7 is one of my personal favorites because I've always been a fan of Lincoln. I was just telling this gentleman here right before starting that a number of years ago as a law professor, I became frustrated with how constitutional law students would not analyze the Constitution. Instead, they would think with their politics, right? They would decide what the proper result was and then reason backwards to how they wanted the text to be read to do it. It actually reminds me of the way my high school chemistry lab partner and I used to do experiments, right? My buddy Cal, who appropriately is now a lawyer, he was sort of an expansive character, and he still is. He's now a lawyer in Wausau, Wisconsin, and he would announce our methodology for doing experiments. It's first, draw the desired curve. Then plot the data. If time permits, do the experiment. And that's what I found is the way that law students and many people today do their constitutional law. Pick the desired result and then try to make the analysis match up with it. Well, at some point in the early 90s, a colleague of mine and I decided that we would cure that by trying to teach a constitutional law course, all based on issues that were no longer of any current relevance. Right? We'd go with 19th century. We said, well, actually, there were a lot of interesting fundamental constitutional issues decided between 1820 and 1880. Slavery, secession, civil war, and none of this could have any possible salience, and so people will actually analyze the issues neutrally. That kind of backfired on us after 9/11, when issues of military commissions, detention, suspension of habeas corpus, and presidential military power resurrected. And so, strangely enough, our course became relevant again. Well, my title for this talk today, I have a handout, because what sort of a professor would be if there isn't a handout? Don't worry, this won't be on the test. Okay. My title is Lincoln and the Constitution, the Great Emancipator as Great Interpreter. Okay? And one of the themes of Chapter 7, which is, this Civil War era constitutional history, is that the Civil War, in addition to being so much else, crucial turning point in the nation's history, probably the defining pivot point of American history. In addition to all of that, the Civil War was also a drama of constitutional interpretation. The really big issues in our nation's history of interpreting the Constitution were resolved during the Civil War. And it's interesting, they were resolved not in any court of law, but on the battlefields. Okay? The great issues of our Constitution's meaning are things like, what is the constitutional status of slavery? What is the constitutional future of slavery? Who will determine that? Who determines the meaning of the Constitution? What is the nature of the federal-state relationship? What is the nature of union? Are we a union of sovereign states where the states are sovereign, or is the nation as a whole sovereign? This was the issue of secession and Civil War. So all of the great, grand, big ideas of constitutional law were decided not in a Supreme Court decision, but in the case, so to speak, of Grant versus Lee. Right? Decided at Appomattox Courthouse and reduced to final judgment in April 1865, about 150 years ago, which is about the time that this article came out. And we were trying to pitch it for the 150th anniversary of the conclusion of the Civil War. Well, if the Civil War was the most important event of constitutional interpretation in our nation's history, a great act of war over constitutional meaning, then Lincoln, in addition to being so much else, was the nation's most important constitutional interpreter in its history. He was really a commander-in-chief of a war over constitutional meaning and over the Constitution's future. So what I'd like to do is talk a little bit about Lincoln as a constitutionalist, Lincoln as a constitutional interpreter. I don't know if it will have any direct lessons for today's constitutional interpretation. In this book, we're trying not to be too doctrinaire and ideological, but I think that certain lessons emerge and that readers will sort of draw their own conclusions, and hopefully a few of the ones that I think are correct too. An occupational hazard of lawyers, is to view the Constitution solely in terms of judicial decisions, right? Solely in terms of what courts decide. And I think that leads us to neglect the centrality of other political actors in constitutional interpretation, including Lincoln, who was trained as a lawyer and was actually, I think, a marvelous constitutional lawyer. I made joking reference to the case of Grant versus Lee. I put that in a law review article referring to the result of the Civil War and how the great issues were decided on the battlefield. and I referred to the case of Grant versus Lee, and I dropped a footnote as law reviews are put. And I put Appomattox Courthouse, 1865. And the editors of the law, student editors, it was a prestigious university. I won't mention University of Michigan by name. Wrote back and said, we are having trouble finding the citation for the case on Westlaw or Lexis. Could you please provide a reference? Which actually shows the narrow perspective of lawyers, law students, legal training. They think of the Constitution solely in terms of what courts decide. But really, the Constitution's meaning is settled less by precedents than by presidents, right? The great issues are resolved often by wars as much as by words. And that's part of why I think Lincoln as constitutional interpreter should be so central to our constitutional understanding of history and the future. Now, my next little subheading is to talk about Lincoln's implicit method of constitutional interpretation. How many lawyers or recovering lawyers are out there? Oh, okay, I just need to know how, really, okay. It's good to see a recovering lawyer doing something productive like selling books. Well, stop me if I get too technical, but that's actually part of the challenge, is to explain these concepts to ordinary people. I kind of have 4 points about Lincoln's approach to constitutional interpretation. And the first is that he was what we might call today a textualist, meaning that he was actually concerned about reading the words of the Constitution and giving them their natural, ordinary meaning as they would have been understood at or about the time they were adopted by ordinary speakers and readers of the English language. He read the words of the Constitution and took them very seriously. He also was not a result-driven constitutional interpreter, in that, for example, he was anti-slavery, but he recognized the extent to which the Constitution's provisions actually did protect slavery, and he was unwilling to read into the Constitution his policy preferences, even on an issue where the Constitution did things that were contrary to his moral and political instincts. And I'll have more to say about that in the specific context of slavery. So he was a textualist. He took the words of the Constitution seriously. My second observation is that he was a pragmatic textualist, and that is that he viewed the Constitution as a whole. He was what you might call a whole text textualist, who would be sensitive to the structure of the Constitution, the relationships it created between institutions, and the purpose of the document as a whole. He sort of had an enlarged sense of the constitutional enterprise. Lincoln took very seriously his oath of office, and there's a specific one prescribed for the president. He swears to preserve, protect, and defend the Constitution of the United States. And he used that as a lens through which he would consider various specific issues. So it's impossible to have an approach of preserving, protecting, and defending the Constitution of the United States without having a sense of the overall constitutional enterprise. We have to preserve the nation whose constitution it is in order to preserve the Constitution. And that the specific parts of the Constitution sometimes need to be read with the whole in mind. Okay? And you can't read a specific part in such a way that would do damage to the whole. If you think about it, it's another approach to textual interpretation, but it's one that views the document holistically and practically and pragmatically. A third point about how Lincoln is as a constitutional interpreter is that he was actually astonishingly formalist. Now by that, I mean sort of a lawyer's turn square corners approach. Right? He read the words, he took them seriously, he read them in context and read the whole Constitution as an entirety. But he was also in some ways kind of formally legalistic in that he would take facts and make sure they were squeezed into the appropriate legal framework. Now, I'll say more about this when I talk about 3 specific controversies, issue areas. But just for example, with secession, Lincoln's constitutional conclusion was that a state could not secede, okay? That it was unconstitutional. He then was very formalistic about what followed from that. If a state may not secede, then a state has not seceded. Virginia has not left the Union. It just lacks a proper Republican constitutional government. And actually creates some very interesting situations. About 15 years ago, I co-authored an article called "Is West Virginia Unconstitutional?" And it was really a lot of fun to do. But here is the short story of how West Virginia was created. Virginia seceded. A group in the western part of Virginia, in what is now West Virginia, resisted secession. They were more pro-union. There was a division within the state. Lincoln and Congress said, that's Virginia. The loyal government, because a state cannot leave the Union and must be represented, we will recognize as the government of Virginia this cabal out in the western Hicks of West Virginia. That is the legitimate Virginia government. Then the next step is to create a new state out of an existing state. You need the consent of both states, which actually makes sense. It's there in Article 4 of the Constitution. So what happened to create West Virginia is that this rump Virginia government in exile at Wheeling, West Virginia, gave consent to the Constitutional Convention consisting of the same rump legislature at West Virginia. And Wheeling gave consent to Wheeling so as to create a new state complying with the Constitution. Now that's what I call formalism. It's like only a lawyer could love it. But it's actually sort of lovable and it sort of works. It is a sort of strict fidelity to the Constitution where you actually are sensitive to constitutional niceties. And sometimes the facts have to be squeezed into the legal framework, but it's a way of actually being very sensitive to and respectful of the Constitution. My last point about his methodology, I've probably used up all my time just talking about that, is that Lincoln was not a judicial supremacist. Now, today's modern myth is exactly the one that my son found in his textbook, that whatever the Supreme Court says goes because the Supreme Court has said so. And the Supreme Court keeps saying things like that. This was not Lincoln's view. Lincoln understood the role of courts to be to decide specific cases under the Constitution, but that the nature of our system of separation of powers properly meant that no one branch could decide constitutional issues wrongly in a way that would bind everybody else. Okay? He said the oath of the president to support the Constitution gives him an independent power and duty, an obligation to interpret the Constitution faithfully, even if that is in conflict with how the Supreme Court has done it. In fact, Lincoln sort of rose to political prominence as an opponent of the Dred Scott decision. Okay? In the Lincoln-Douglas debates, they are all about Lincoln's resistance to the proposition that whatever the Supreme Court says goes. Douglas, in that 1858 Senate campaign, said, you are defying the Constitution. The Supreme Court has spoken. And Lincoln's view was, the Supreme Court has decided that case, but they have no more authority to decide it for the political branches of government than the political branches of government have to decide legal issues for them. Okay? Sort of a non-judicial supremacist view, and I think that does have some lessons for today. So with those sort of broad interpretive things, let me just, sketch out in about 10 minutes. This is why you give an outline, so you can see how far behind you're falling. Sort of three broad sets of issues. I'm going to talk about Lincoln's stance on slavery, Lincoln's stance on secession, and Lincoln's stance on the commander-in-chief powers of the president in time of war. And I'll just say a little bit about each one. Before the war, before the 13th Amendment was adopted at the close of the Constitution, ours was a pro-slavery Constitution. Now, that creates some controversy in certain circles. I've taken this lecture, or some form of it, down to Virginia, and you get different views of this. Okay? But I really think, and this is chapter 4 of the book, is all about slavery and the ways in which the original Constitution accommodated, protected, and even encouraged the institution of slavery. There's the Fugitive Slave Clause, which wasn't there in the Articles of Confederation. There is the 3/5 Clause, which was the clause counting how many state representatives you get based on population. And the big argument of the Constitutional Convention was whether the South would get votes in Congress for representation based upon slave population. The position of the North was, no, if these are persons who are denied rights in any form, you shouldn't get enhanced representation based upon them. The position of the South was, well, they are people and they are an aspect of our wealth and we should have representation. And the notorious compromise of the Constitutional Convention was to split the difference and basically count African American slaves as 3/5 of a person for representation purposes. Now, the shallow version of this is like, this is terrible because you're counting them as 3/5 of a person. And it is that, it's offensive in a symbolic way too, but really it's important to keep your eye on the ball. You would not want the slaves counted as 5/5 of a person for representation purposes. Because a consequence even of the 3/5 Clause was that the South was systematically overrepresented in Congress and in the Electoral College and in the administration of laws and in the appointment of Supreme Court justices by virtue of the slavery bonus given by the 3/5 Clause. And finally, there's this notorious provision in the original Constitution that prohibited Congress from restricting the slave trade, the importation of more slaves from Africa. Yeah?
Quick question.
Sure.
Did the Southern delegates push for 5/5?
Oh, it's not in the record. The 3/5 ratio had been something that had been picked up from an earlier proposal of the Congress under the Confederation about how to allocate taxing burdens. So it was a compromise that had been out there and never adopted before. But let me just mention that last provision, which the Constitution is pro-slavery, which was it forbade Congress from prohibiting the slave trade for another 20 years, which in practical effect became a, on your mark, get set, go, import as many slaves as you can for 20 years. In addition, very early on, and I think this is more debatable, it became the accepted understanding that the Constitution did not give the national government the power to prohibit or limit slavery in any state, that it was a state's rights. Now, our contemporary association of Lincoln with being the great emancipator often leads us to overlook what Lincoln's stance was on all of these issues before the Civil War. And that is he accepted them all. In fact, in his first inaugural, it's sort of jarring, he offers to agree to a constitutional amendment that would be unamendable and permanently protect the institution of slavery in the states that so chose it. He said, because I understand that to be implied constitutional law now. Lincoln was an anti-slavery moderate. He recognized the ways in which the Constitution was pro-slavery, and he was pro-Constitution, and he accepted them all. Where he drew the line was that he believed that the Constitution did not require the national government to accept the expansion of slavery, the extension of slavery into new territories. So he was a free soil, moderate anti-slavery Republican. The Dred Scott decision in 1857 held that there was a constitutional right to slavery and that the Missouri Compromise prohibition on the extension of slavery into certain northern territories was unconstitutional. Lincoln said that that decision was wrong, and that, as I mentioned, is how he rose to prominence as an opponent of the Supreme Court. To fast forward in the story then, the crisis of secession arises when Lincoln is elected president. Because think about it. From the South's standpoint, we have just elected a president who's committed to resistance to what the Supreme Court has said is their constitutional rights. the South secedes to allegedly protect its fundamental constitutional right, declared by the Supreme Court, to take slaves into new territories and to form new slave states. So Lincoln's election is the trigger for secession. And Lincoln resists secession, and again, it is all driven by his constitutional interpretation. Okay? Lincoln's view of the Constitution is that it creates a nation, that it is no longer, if it ever was, a union of sovereign states, and that constitutionally, no state has a right to leave the Union in violation of terms of the Constitution that the Union must respect. It's really a very interesting structural argument that's buttressed by specific language at a couple of points in the Constitution. You know, the preamble says to form a more perfect union. Various provisions of the Constitution forbid states from forming confederations or alliances, and that's violated by secession. But really, it's a careful, logical, deductive proof of why secession is unconstitutional. Then in terms of Lincoln's approach to being formalistic, okay, once it is clear that secession is unconstitutional, Lincoln understands it to be his bound duty by virtue of his oath to resist it with all the powers of it at his disposal. It was not an option to acquiesce in secession. It's really not too much of an exaggeration to say that Lincoln fought the Civil War out of a sense of constitutional obligation, that his duty of faithful execution of the laws required him to preserve the Constitution in the fashion it had been handed to him, and that he had really functionally no choice but to resist secession. Now, he was pretty strict, as I mentioned, about these legal fictions. Virginia had not left the Union. In fact, he was doctrinaire in refusing ever to call the Confederacy the Confederacy. No. He would always say the quote-unquote Confederacy, or the so-called Confederacy, or the rebellion. And it is why the Civil War was never a declared war, because Lincoln was strongly of the view, and the Republicans in Congress strongly supported it, that you didn't declare a war on a non-sovereign entity. Because the Confederacy was not a legitimate thing, this was merely a treasonous, organized rebellion that was taking the form of war. So that'll be my last point, is about the military powers of the president. Okay? Lincoln took the view, and I think correctly, that the president's powers of war exist to their full extent whenever there is an actual situation of war, whether it be declared war or an undeclared civil war in the form of a rebellion. The president's war powers are the same where there is an actual shooting war and organized armed conflict under the laws of war. And that becomes his basis for really the most aggressive action he ever took as president, which was the Emancipation Proclamation. Fabulously unpopular at the time, leading to dramatic race riots in, of all places, New York City in the summer of 1863, the worst riots in our nation's history. Baltimore was nothing compared to New York City in 1863. The Emancipation Proclamation was hugely controversial both on policy grounds and on constitutional grounds. The argument was that the president could not seize property and take unilateral executive action. Now, Lincoln's defense of the Emancipation Proclamation made use of the Commander-in-Chief Clause power. And actually, this is instructive for some of today's controversies. He said that the Commander-in-Chief power was a power to take measures to most effectively subdue and harass the enemy so as to defeat it. Okay? That in a time of legally authorized war, the president gets to decide matters of how aggressive to be in the combat of war. And that one of the traditional powers of war in the 18th and 19th centuries was the power to seize enemy materiel and property. The legal rationale, the constitutional rationale for the Emancipation Proclamation was a strictly formal rationale that we are seizing enemy property. What that meant is that the Emancipation Proclamation was only effective in areas of the Confederacy's control. There were still 4 slave states in the Union, and Lincoln did not assert a power to free the slaves in Delaware, Maryland, Missouri, and Kentucky. That guy had it right. Rather, the power to free the slaves did not flow from a unilateral presidential power to make executive orders having the force of law, but from the military commander-in-chief power to wage effective war against the enemy. So those are just 3 illustrations of the Lincoln's constitutional theory. The lesson I draw from it is that Lincoln took constitutional proprieties and constitutional considerations very, very seriously indeed, and that they actually animated every action he took as president of the United States. His legacy is huge. Right? I think our nature of our union, the fact that it is inconceivable that anybody would contemplate secession today, is because of Lincoln's understanding of the Constitution. The abolition of slavery started by the Emancipation Proclamation and completed by the adoption of the 13th Amendment, which was adopted because Lincoln wasn't sure that a military order would survive the end of the war. Is also just a dramatic transformation in our constitutional order. And also, I think that our current modern conceptions of the powers of the president as commander-in-chief flow from Lincoln's full use of them in the Civil War. So that's why I'm a tremendous fan of Lincoln as a constitutional interpreter. I've talked way over time, but I could still handle questions for as long as you ask.